spotlight of disinfecting transparency down upon the system with the idea that we want to root some of this stuff out. We want to get rid of the bad, the malcontents, the people who are part of the system that aren't adding anything of value to it, and support those who are doing good, who are fighting for the people like you and I. So what we want to do today is talk about it. And if you are a regular of the program, thanks for being here. If you're not, do us a favor and hit the subscribe button, because for a long time we've been really doing a deep dive on the election. Election 2020 is still going on, and what we've been covering here is the legal battle. I've called it the legal battle of all time, the world's biggest war going on right now in the courts, but not only in the courts, outside of the courts as well, because a lot of what we're seeing sort of unfold is pseudo-legal. We're seeing these legislative hearings here in Arizona today. We also saw them recently in Pennsylvania. And there's a lot going on that we need to dissect. So we're going to do that today, and we're going to break it down into a couple different segments. So first and foremost, I want to talk about the Pennsylvania Supreme Court. We're going to get to that order and that ruling that came out over the weekend. There was a lot of activity. We had a long weekend very recently, and there's been a lot of updates going on. So Pennsylvania Supreme Court, they dismissed a lawsuit out of their particular court. We want to know why, because they're using this really interesting, antiquated legal doctrine known as latches, which is something that you don't hear about too much anymore. So what are they doing? Where did that come from? Why are they sinking their teeth in on that issue? Is it relevant? Is it going to be overturned on appeal? We're going to talk about all of those different questions. The other thing we're going to really spend a lot of time on today is the Sidney Powell lawsuit, the Kraken case that is developing out of Georgia. There was a lot of activity there as well. We have the federal court docket. I want to show you the flurry of motions that were filed over the weekend and over the holiday as well, because there's some interesting things in there. We have a new affidavit from Dr. Shiva, which we've already talked about some of his information on the show. He has this big 40-something page affidavit that he filed. We want to break that down a little bit. We also want to talk about the hearing that took place in Arizona, which is sort of a lot of what we saw in Pennsylvania, which we covered previously, but Ms. Faith, who is back there, found some very good clips, and we're going to run through those with you as well today. So, quick reminder again, if you're not already a subscriber, now's a good time to hit the subscribe button. We go live at this time every single day of the week. We want you to be a part of the program. Another reminder to join us on our Discord server, because that's where the chat continues after the show's over. It's this chat platform where we can all communicate. We also will share the slides, exactly what I'm going to present, in the Discord server after the show. So if you want access to that, links, any of the original files on this episode, I have a lot of legal documents that we're going to go through. Going to try to make it not so mind-numbing. You're going to see a lot of walls of text, but we're going to try to break it down and communicate it in layman's terms so that we can all understand what's going on, including myself. So let's dive into it. Like I said, I want to start with something that we've been spending a lot of time on this channel covering, which is the Sidney Powell lawsuit. Last week, actually on Friday, we came in, did a little bit of a Black Friday show, and went through the original filings. Remember, these all came out on Thanksgiving Day in Michigan and in Georgia. We talked a lot about the underlying lawsuit, the underlying base complaints, but new stuff was filed over this weekend, and one is interesting. It's a big document, and it introduces some new evidence, so we want to break that down and show you what's going on in that new document. So let's take a look. Here is the U.S. District Court docket. We pulled all this information up from PACER, which is the federal online access, case record access portal. And you can see here, this was the original lawsuit we were talking about last week, Pearson versus Kemp, filed on 11/25. And you see here down here, it's Lynn Wood Jr., who is the official attorney on record according to the U.S. Docket. This is the Northern District Court of Georgia, which is the U.S. federal court. And you can see down here, Ms. Sidney Powell signed this new motion, which was submitted on November 27th. So that was on Friday. And it's called the Plaintiff's Emergency Motion for Declaratory Emergency and Permanent Injunctive Relief and a Memorandum in support thereof. So Sidney Powell, who is, my understanding, is not licensed to practice law in Georgia or the Northern District of Georgia for the Federal Circuit. And so she is sort of piggybacking on Lynn Wood and Harvey McDougald, who are these two attorneys who are actually filing the lawsuit. So Sidney Powell signed off here, but she has this little asterisk by her name. It says her application for admission pro hac vice is coming, which means she's moving the court to allow her to go in and practice. Now, what I want to show you next is a breakdown of all of the different minute entries, basically all of the things that have been happening in the case since November 25th. What I'm going to show you is going to be a huge wall of text, so don't jump out the window. But let's take a look at it. We'll break it down briefly. I want to highlight some of the areas that we're going to go through in this new filing. So this was filed on November 25th, as we see here. The very top item has all the different complaints, all of the different exhibits. This is what we covered previously. So Myra Romero, Nicholas Zahara, we've got Carlos Silva, we have an exhibit from the Texas Secretary of State rejecting Dominion. We have just a number of different affidavits and reports and so on and so on. And this was all filed on November 25th. So then a couple days later, we have some minor things going on. The court notifies them about their COVID policies and so on. Summons get mailed out on the 27th to a number of different people. We have a certificate of interest, a motion to leave. But then something happens very interesting on 11/27. We have a new motion that is filed with some new information. So let me move my image out of the way over here. Let's put it up there. And what we'll see on November 27th, this number 6 docket number that was filed, we have a motion for a temporary restraining order with bold red, immediate hearing requested, and motion for preliminary injunction, and so on and so forth. But what we want to look at here are these two new affidavits that I have underlined in green, and you can see that there was an affidavit declaration from Dr. Shiva Ayadori, who we're going to talk about, and there's another one from an exhibit, a joint cybersecurity advisory exhibit, and then we have some text of an order. So this is new. This is new information. We have a new affidavit, and this was not included in the original filing that was 2 days prior to that. And so as we move on, we're going to see what happened shortly thereafter. So on the 29th, that was going to be, on the 27th, that was Friday, so nothing was filed on Thanksgiving. So on Friday, nothing happened, we have all these motions filed. On Saturday, nothing happens, but then yesterday on Sunday, look at all these court entries here from November 29th on, and then a whole slew of activity. Also today, literally today, we just pulled this right before the show, and what you can see here is there's additional notices, additional summons that are going out, and then we have these three these three arrows that I put on the slide here that say we have 3 different orders. And so you may have seen some of this in the media over the weekend, largely sort of this back and forth ping pong of, oh my goodness, a judge in Pennsylvania acted and Trump won a lawsuit. You saw that from some people in the Trump team. I think maybe Ms. Powell or somebody in his team was sort of amplifying these claims, saying Trump won because a judge said that they can't go in and erase all the tabulation data from the tabulators machines. Big victory. Well, then shortly thereafter, there was another order from the same judge in the same court, and seemed to sort of undo that. So this judge came out with an order, said you can't go wipe your Dominion machines, you want to keep those records available because there's an investigation going on. Then a couple hours later, there was another order that says, well, hold on, not so fast. And then shortly thereafter, there was another order that says, okay, actually, yeah, we're going to kind of keep moving forward the way things were. So there was a big back and forth. The right wing was very excited when the first order came out. The left wing was doing cartwheels when it was immediately reversed. Hey, look, Donald Trump lost again. His team are a bunch of idiots. And then now not so much, because I don't think anybody knows what's really going on. So we're going to explain what happened here. But it is interesting because these are interesting claims that are sort of new and novel claims. Because remember, the original lawsuit, one of the main claims, one of the main remedies that they wanted to get across to the courts was to stop the certification. Remember, it was all a big race to stop the certification. Well, Pennsylvania is now certified, and these motions are coming in after the certification, so what are they doing? Are they going to ask to rescind the certification, or are they going to ask to modify it, or to stop the legislature or from the Secretary of State from transmitting the documents over to the House of Representatives? What's going on here? And is this the framework, is this the idea that they're going to be using in the other states? Because Arizona just certified our results today, and maybe this is what their strategy is going to look like. We're starting to see what the different arguments are going to look like as these cases progress and as we move past certain deadlines, because we're moving past certification deadlines in many states, but these lawsuits still keep coming, so what is the deal? Well, let's take a look at it. As I said, when you go through our slides, if you get them in the Discord server, you're going to see a bunch of these different documents in here. When you pull these slides, you can actually just double-click on the slide, or double-click on each one of these images. These are PDF files that are in the slide, so you can come and take a look at it. So let's take a look at what the original document said. So we had the original court filing, but then we have a new motion, this new one that was filed on the 27th, which was on Friday, that we now have a number of different orders about. So again, it's hard to keep track of these things, but this is the newest information in the Georgia case from Sidney Powell, from Linwood. This is their lawsuit. This is the Kraken lawsuit, and there's an additional information that was filed that we're learning about over the weekend. So if you want to skip all that procedural history stuff, this is where we're at now. And Ms. Powell goes into her motion and she opens it with this statement. She says, after a general election and a hand recount audit, Vice President Biden was declared the winner of Georgia's general election for president by a margin of 12,670 votes on November 20th. But the vote count certified by the defendants on November 20th is wrong, and I have that underlined in red. That's their argument. They're going to say, all right, well, it's certified. It's great. Certified. Good job, guys. Pat yourselves on the back. You certified a fraudulent election. Good for you. So what? The vote count certified was wrong, and that's what their argument is going to be. She says tens of thousands of votes counted towards Vice President Biden's final tally. They were the product of illegality and physical and computer-based fraud, leading to outright ballot stuffing. She says on November 27th, Union County officials advised that they are going to wipe the voting machines of all data and bring the count back to zero on Monday, November 30th, 2020, which is today. Resetting the machines, she says, would destroy relevant evidence now existing on each voting machine. This cannot be allowed. So that's the main crux of this additional motion. She's saying, okay, look, it's been certified, that's great. We're going to need to continue our investigation. The vote certification was wrong, but we want access to the machines. We want to go see what was going on here. So the rest of this document is really supporting that claim. Then we're going to get to the order, and we're going to see what the judge has to say about that. Is this evidence convincing enough? This is the material that was presented to the judge before we get to the order. So we're going to get to that order that I already explained, this kind of weird, order, then a reversal of the reversal. But this is what the judge was reading or seeing prior to issuing those orders. So let's go through it. And remember, in my previous video about this type of content, about this type of legal analysis, the two questions that we were asking ourselves was, number one, is it baseless? Is it baseless? Is there any basis for this at all? And then number two, if it is, can it get over that basic threshold, that preponderance of the evidence standard, in order to say if we gave it the best evidence, if we gave it the most time, if we gave it all the benefits of the doubt, if we looked at this evidence in a light most favorable to the people making the claim, in this case Sidney Powell, her team, Trump supporters across the country, if we look at it most favorable to them, is there anything in here that maybe could be more likely than not that there was some fraud that took place that had an impact on the outcome of the election? That's what we're asking ourselves. We have to be very, very favorable to that side. If the answer is yes, or if it's questionable, then maybe it's most appropriate to be heard in court. Maybe it's most appropriate to let the case go forward so that these claims can be litigated on the merits and not thrown out just because the judge has some procedural problem with the case. So that's what we're asking ourselves. Baseless, and is it going to meet the burden? Is it going to go over that hurdle? And if it's just enough to even be questionable, then the appropriate form in my mind is to have that heard in court. So let's ask ourselves those questions as we go through here. Now there's some additional stuff, additional sort of paragraphs we're just going to cover on briefly. If you want to read the full complaint, it's big. It's about 100 pages long, so you can go take a look at that as well. So let's dive into it. One of the first things that she brings up is this sort of one of these little bits that we've already heard from Rudy Giuliani, but they put it into a nice little chart here, and I wanted to share that. So we see one of the first main sections is talking about mail-in ballots and a pattern of fraud. She says sworn affidavit testimony, detailed analysis of the election results show that 96,000 votes were illegally cast, 96,600 mail-in votes. There's a plaintiff, there's a different expert witness. I think we've already talked about this guy before, but he says in one of his affidavits, says the first red flag comes from the mail-in dates, and he goes through this analysis and he breaks down. He says the voter records of the county show 96,000 mail-in ballots were voted, but the county records show that they were never received back. So how do you have a vote that voted, but you don't have any record that you got the vote back? He says 42 mail-in ballots were received back before they were mailed out to the voter. 1,800 were received back completed the same day they were mailed out. 1,700 mail-in ballots were received back completed one day after they were mailed out, and then 2,200 were received back after 2 days. Basically, those numbers are impossible. So he goes through and he adds them up, and we get to this number of about 96,000. So you see here in this chart, he just adds them all up. Total ballots with impossible mail out and received back dates were 5,900. Ballots returned with no record at all, 231,000. Ballots returned with no record and canceled, and so on. So they're identifying 96,000 potential votes that are in that bucket of questionable votes. And before we move on to the next document or the next slide where we have a little bit of information about what Matt Brainerd was able to pull up, think about this. One of the criteria or the arguments that Sidney Powell and her team are making is that you don't necessarily have to show that the election would have gone in favor of Donald Trump. You just have to show that we don't know. We just don't know what it is. And so this is a little bit of a different standard than what they've been purporting to argue previously. Previously, we've seen a lot of language here saying that any of these questionable votes, any of the votes that are in the bad signature bucket, or out-of-state voter who shouldn't be voting in our state bucket, or ballots came in 3 days after the deadline bucket. They're identifying these big buckets. And previously, those buckets were, the allegation from the Trump team was that every one of those buckets should have been for Donald Trump. Not, okay, well, that's a questionable bucket, and we want to split those up. It's either really been, well, we're going to throw all of those out, or all of those need to be counted for Donald Trump. And we on this program, we read some of the language, and we're like, that doesn't make any sense. If you have a bucket of disputed votes, clearly those are not all going to be for Donald Trump, right? Just the same rationale that people have with questioning all of these big spikes in Biden's votes. Many people in the media are saying, well, those are just natural votes and natural patterns, and those are just certain precincts being counted that are majorly in favor. That's ridiculous, right? There's no way that a bucket of votes comes back at 99% for one particular candidate. So when Donald Trump was making the same argument, we were a little questionable about that. But here, we're not seeing that anymore. Now these buckets are not all Donald Trump's votes. They're just unknown votes, and the buckets are bigger than the difference in the election, bigger than a bigger differential between Biden and Trump. And so now they're just saying it. We just don't know who it is. We don't know what it's about. We don't know where those votes would end up. But because of that uncertainty, that's a justification for what they're asking for. It's a justification for their relief. And so that's a little bit of a nuance there. It's kind of a technical distinction, but I think it is important because it's changing a little bit. It's getting a little bit more narrower. And as it gets more narrower, judges and I think legislatures are going to be more inclined to grant the relief that they seek. Previously, the request that the relief that the Donald Trump team wanted was so big. He was saying we're going to have to throw out 6 million votes or 7 million or whatever it was, huge buckets. And we've talked about it here that there's no way a judge is going to do that. Even if the evidence is pretty compelling, they're just not going to do that because the court system is based on legitimacy. And if the court comes in and overturns the will of the people, the court's going to lose all their legitimacy and out goes the window their power. So they don't want to do that. And now, as this is getting more and more reasonable, their claims for relief are becoming more, I think, more grounded. Maybe we're going to see some results. So that is the first bit of evidence. We see this chart here, 96,000 votes. We don't know where they go. We don't know what bucket they're in, but there's 96,000 of them, and they are concerning. We also go through and we see that principle sort of play out here in some of Matt Brainard's data. So Sidney Powell goes through and says, separately, evidence gathered by Matt Brainard in the form of recorded calls and declarations of voters, they were analyzed by plaintiff's expert, William Briggs, and they show that there is a statistically significant sample. The total number of mail-in ballots that voters mailed in but were never counted have a 95% likelihood of falling between 31,000 and 38,000 total lost votes. This range exceeds the margin of loss of President Trump by 12,600 votes by at least 18,000 or as much as 26,000. And so you can see sort of where, if you read between the lines on this argument, you sort of see that it's a good argument if you're trying to prove the case that you don't know how a missing 31,000 or 38,000 votes would impact the election. You don't know, right? There's a big bucket there. The margin that Donald Trump lost Georgia by is 12,000. We got a big bucket of 31 to 38,000. All right, so if we found those votes, it could change the election. Now, is it likely to? Probably not, right? Because if you have 31,000 votes, Donald Trump has a margin of 12,000. He needs to win that bucket of votes by a 2-to-1 margin, right, in order to close that gap and flip the election. So is that by itself enough to flip it? Probably not, because even if you did find those 38,000 votes, unless this was something that it was sort of systematically disenfranchised Trump votes, then yeah, maybe it does come back 2-1. Maybe it comes back all for Trump, or a significant portion for Trump, or higher than 2-1, or 80 or 90%, right? Because this is just one part of the claim. The rest of the document is making bigger allegations, saying that this is just one component, this is one puzzle piece. There's a lot more of deeper depths of malfeasance across the board. And so Sidney Powell's lawsuit goes on. This is the addendum. This is a new motion. She says in paragraph 2 that there's ballot stuffing going on. Georgia's election process depends entirely on voting machines and software poaches from Dominion voting systems. Computerized vote recordings and tabulations are controlled by software that were literally designed to cheat. We've seen this type of language a lot. She says these were open to human manipulation. In 2020, ballot stuffing is not simply counting votes of dead people, illegal aliens, and so on. All this occurred here, but sworn affidavit testimony, detailed analyses of reported election results now demonstrate that over 135,000 votes were illegally transferred from President Trump to Vice President Biden through an algorithm embedded in Dominion software. And so this claim is pretty strong, and we already saw that affidavit in a previous exhibit, but this was a lot of the data that we were speaking about, where they were showing these big graphs and these spider webs of interconnected data, and we have name servers going to IP addresses and so on and so forth. Some of that stuff is over my head in terms of the technicality, but people with 35 years of background in computer forensics and detailed analytics and so on, they were putting together these massive affidavits that seem to detail it pretty clearly. And one of our critiques about the Trump campaign's claims was that it's hard to do that. And one of Sidney Powell's, I think, shortcomings for a long time was this idea that this software was created in Venezuela for Hugo Chavez. All right, so what? That happened how long ago? Well, what happened here? And now they're now they're connecting the dots. It's starting, the bigger picture of the allegation is starting to come together. We also see, I saw an interesting point about that so-called flood, that water main that broke and it forced a number of different observers to leave the counting facility. So remember this story, and it's in Sidney Powell's new motion, and we're learning here that was not so true. There's actually video of it. So here's what she says. She says, manipulation of votes was apparent shortly after the polls closed on November 3rd. At approximately 10 p.m., election officials evacuated the State Farm Arena where votes were being counted, and they said that it was due to a plumbing leak that represented a threat. This was a lie. Here underlined, she says, video of the location at the time shows there was no flood and no emergency. Instead, after all challengers and other personnel left, several election workers stayed behind and continued to feed votes into Dominion tabulators for over 3 hours until 1 a.m. on November 4th. All right, so see, when you start to kind of connect these things together, now you start to see where, well, some of the numbers are off, numbers don't make sense, there's a bunch of missing votes, and then you kind of connect the dots here, and apparently there's a handful of people who kick everyone else out and then have 3 hours alone, unfettered access to a bunch of vote tabulating machines. It doesn't look so good. And all this, again, is happening in Georgia, all part of the same lawsuit. This is one localized incident of connecting the dots. Locally in Georgia, this is what happened, and just slowly, methodically connecting one thing to another. Then we see, as her document continues to unfold, we see this affidavit from Dr. Shiva Ayaduri. And now this guy has been the subject of the show previously. I'm going to pull up his memorandum here. Let's take a look at this entire document that Sidney Powell submitted over this past weekend. So you can see here, there's a lot of information here. The table of contents, we have the certificate of service. This is the case of the list of all of the different cases that are part of her authority. And we just keep scrolling. This is all part of her claim. And at some point, we're going to get down to Dr. Shiva's declaration, his affidavit. And I want to run through it, not because I want to give you a detailed breakdown of it. It's about 40-something pages long. I just want to show you sort of the work and the analysis that went into it. So it starts, obviously, he's over 18. He's an engineer, vast experience, engineering system. He attaches his resume near the end of the document. I'm going to show you that. He actually ran for office at one point in time. And he goes through, and you can see in paragraph 5, he talks about how this works. There's a digital scanner that scans the ballots. It makes an image of them. It puts them in a document, such as a PDF or an image file. You can export some of this data into an Excel format. There's an electronic image of the actual ballot used, so every single ballot goes in, it's scanned, it's part of the record. And remember, let's back up a little bit. What Sidney Powell is asking for here is to not let them wipe these records clean. She does not want the Dominion software to be wiped, right? And this is where she's making her claim. And this is what Dr. Shiba is doing. He's going through and he's explaining why it's so important and how these machines work. Now, you can see here in Chatham County, he's got all of these different graphs, these very localized analyses of the different precincts in Georgia. And he says the graph below shows the percentage of Republicans in the precincts, and then he compares those with these different patterns, and it just goes on and on and on, right? And you can see this is all statistical analysis here. And we have more data from Fulton County, Trump actual votes versus the projected votes. More out of Fulton County, we've got actual votes, Biden versus Trump, and then the gap closes. He does ethnicity-based distributions, all sorts of just very, very, very detailed analytics. Page 16, page 17, page 19, and so on. And this is why this data is pretty important, is because if this is gone, then the ability to analyze a lot of these records goes away. So he finishes here, he says in conclusion, the declaration has presented in multiple counties a consistent pattern of high Republican, low Trump vote pattern anomalies. It was discovered that ethnic distributions were applied to 3 counties. The only plausible explanation for the vote distribution was that President Trump received near 0 black votes, which is also highly improbable. He goes down to DeKalb County. He talks about this weighted race where certain voters are given a higher weight in terms of their vote. So one person, one vote is what you normally think. Here they're saying, no, not so fast. It's about one person, 1.22 votes of approximately the 48,000 votes from President Trump to Mr. Biden. 373 votes were cast, and so on. And he signs it. Now take a look at his resume here. It's about, I think, 10 pages long. This is what this guy's background is. Let's take a look. Consulting software engineer, teaching assistant all over the place, chief technology officer, information cybernetics, modeling. He's got a number of different academic publications, 200 confidential industry publications, white papers and technology, all this different stuff. Right? This is a pretty credible guy as far as I can tell. And he went through some detailed analysis stuff that's over my head for sure, at least just from glancing through that document. But this was all presented to the court. This was all presented to the judge in district court. And what did the judge do? Well, he issued an order. He actually issued 3 orders, the first order, a second order, and a third order. So let's see what he had to say. Now, as a reminder, what did Sidney Powell want? What did the Trump people want? They want to show that there's more evidence. It's continuing to come in. And all of these other individuals are doing their own analyses that are now being incorporated into the bigger picture. So we have Matt Brainard out there. We have Dr. Shiba. We've got a number of different individuals on the Trump team who are not part of Sidney Powell's team. So a lot of this stuff is just bubbling up. And they were telling the judge, just stop them from wiping the Dominion software. Prevent them from doing that. That's what an injunction is. It says we want an order that prevents them from doing something. In this case, stop wiping the machines. Here's the order from the judge out of federal court. He says, plaintiffs have filed an emergency motion for temporary injunctive relief. Here they seek an order directing the defendants to allow the plaintiff and their experts to inspect the Dominion voting machines in Cobb, Gwinnett, and Cherokee counties. So that's it. They had a Zoom hearing at 7:45, and they were ruling on this motion. So it's just an order to inspect. That's all. During the hearing, the defendants argued that the Secretary of State has no lawful authority over the election officials, citing Jacobson versus Florida of Secretary of State. Their second argument, well, let me take that argument first. So here's what the government is saying. Listen, we know you want access to the machines. We don't have any ability to go in and make them do anything with the machines because they're all local election officials. So the way that it works is right now, the Trump people, Sidney Powell, Lynn Wood, they're suing the Secretary of State, Brad Raffensperger, and he's the state. He's the person who's overseeing the entire election. So what they're saying, the government is saying, well, okay, yeah, we know you want access to the machines, and we don't have them. They're not our machines. Those are with the cities, the counties, the precincts. And so go talk to those people. We don't have them. Judge, nothing we can do about it. And so what the plaintiffs, what Sidney Powell and Lynn Wood are saying is, okay, that's fine. Here's what we'll do. We'll just amend the original complaint, and we'll just add the election officials. So we'll just go, we'll find whoever's in charge of Cobb, Gwinnett, and Cherokee. We'll just go ahead and add them to this underlying complaint. That's going to obviate the issue of whether the proper officials have been named as defendants to this case. Right? Pretty easy. So government says, oh, we don't have access to that. The other side says, no problem. We'll just add the people who do have access to it. Who is it? Great. Give me their names. They're getting added onto the lawsuit as well. Well, the defendants, they still don't want to give access to this stuff. They don't want people to come in and look at the Dominion software, to do these forensic analyses. I don't know what basis for it is. Understand the argument of, well, we don't have access to it, so we can't let you in. Okay, that's a separate problem. So in other words, if you did have access, if you did have the machines in your closet, Brad, would you let us come in and take a look at that thing? Or is there another argument that you would raise? Well, yeah, he does. He says, defendants' counsel, they also argued that such forensic inspections would pose a substantial security risk and proprietary trade secret risks to the defendants. So the plaintiffs, Trump's team, or Sidney Powell and Lynn Wood, they said, okay, well, we can fix that, no problem at all. All we need is an order from the court that says, bring your own experts. Okay, so the defendant can bring their own people to come in. They can join us as we go through it. This whole thing can be video recorded, so bring your experts in and we'll video record it. And, we'll ask the court to allow what's called an in-camera inspection. So if the experts get information about it, they're just going to give it back to the court. They're not going to make it public. An in-camera inspection is exactly that. It's when evidence is taken sort of out of the public eye and it's reviewed back in the judge's chambers. It's reviewed off the record so that a judge can make decisions on sensitive information. And you see this in criminal law. If somebody's in the middle of a courtroom and they have a very important, pressing, urgent thing that they need to address, they don't just blurt it out in front of the judge or the jury. Or if something is very prejudicial, it's important to a case, but it's really prejudicial. It's going to be really hard for a juror to look at this and not sort of prejudge our clients or whatever. So what you want to do, you want to just go talk to the judge off the record with that. And that's what they're saying here. So Sidney Powell and her team are saying, okay, look, yeah, there may be trade secrets there. I'm sure Dominion has proprietary software and algorithms and a lot of very good justifications for their security and why they don't want a bunch of people poking around in it, especially people who have a stake in it, especially people who are running for office and who may be able to find an exploit and then utilize that. So their security, I understand their perspective on it, but that can be remedied, that can be rectified, and it's pretty simple to do that. You just bring your own experts. So Sidney brings her expert, the government brings their expert. Sidney says, we're going to record it. They can record it themselves, and anything that is found from that investigation, it doesn't go to the public, it just goes right back to the judge. So the judge can hear the next evidence. And that sounds pretty reasonable to me. So why are they